I'm Todd Cox, one of LDF's Associate Director Counsels. It is my pleasure to welcome you to LDF's webinar, Reimagining Public Education Amid Assaults on Brown and Its Legacy. Thank you all for joining us for what I know will be a wonderful conversation. 71 years ago, the U.S. Supreme Court issued its unanimous decision in Brown versus Board of Education. Litigated by the intrepid legal minds at LDF, including Thurgood Marshall, Constance Baker Motley, and Jack Greenberg, Brown changed the course of our nation's history. It not only deemed the segregation of public schools unconstitutional, it laid the legal foundation for the end of racial apartheid in the United States. Many of the achievements of the civil rights movement were made possible by what was decided on that day over 7 decades ago. Brown undergirds the laws that help prohibit discrimination and protect the rights of individuals across all sectors of society, from housing to employment, from how we vote to who we marry. Because of Brown and the transformative change it wrought, this country has made tremendous progress. But there is no question that we still have a lot of work to do to make the promise of that decision the lived experience for everyone in this country. And right now, our educational system is in a daunting inflection point. The Trump administration is actively seeking to ignore the glaring yet fixable issues in public education, including persistent gaps in achievement, access to high-quality learning opportunities, and resources. State legislators across the country are mulling and passing harmful legislation that would deny students their right to learn the truth. And lawmakers at every level are trying to redirect public education school dollars to private schools, which risks increasing inequality and leaving millions of children behind. Amid this all-out assault on public education, LDF refuses to turn a blind eye towards injustice. As the organization that vanquished state-sponsored racial segregation in 1954, we stand firmly against racial segregation and efforts to let school districts that never desegregated off the hook. In fact, we've already filed 3 lawsuits against the Trump Department of Education, including their attacks on racial equality, data collection, and students' civil rights. Recently, a federal judge blocked the enforcement of the administration's harmful misinterpretation of civil rights law, which threatens Black students' access to equal education. And our work challenging the administration's threats is far from over. Outside of the courtroom, we've been advocating against censorship of truthful teaching and learning in Congress and in states across the country, including Texas and South Carolina. We are sharing resources for everyone who, like us, is determined to stand up for equal opportunity and justice. And today, we are joined by some of the foremost scholars and practitioners of education and civil rights policy for what I know will be a fruitful discussion, not only on the legacy of Brown, but the practical steps we all can take to protect the educational rights of Black students and all students. In bringing this group together, we hope to further equip ourselves and our allies with the tools necessary to not only defend against the attacks on education, but to dream of what an equitable, inclusive, and supportive Department of Education could look like, and take the steps necessary to make that dream our reality. So thank you for joining us. Thank you to our esteemed panelists for their participation, and welcome again to Reimagining Public Education Amid Assaults on Brown and Its Legacy. With that, I'll turn it over to my colleague and Associate Director Counsel, Sam Spital, to lead the discussion and introduce our panelists, including our very own President and Director Counsel, Janae Nelson. Thank you.
Thank you, Todd, and welcome everyone. As Todd said, we have a truly extraordinary panel to talk us through these important and challenging issues today. And I'm going to begin by introducing each of our panelists before we begin the conversation. I'm going to start by introducing Janae Nelson, who, as Todd said, is the 8th President and Director Counsel of the Legal Defense Fund. This is Janae's 2nd tenure at LDF, and throughout her 2 tenures at the organization, she has served in many very important roles for us, including many other leadership roles as Associate Director Counsel, as Interim Director of the Thurgood Marshall Institute, and as Director of the Political Participation Group. Janae has been the architect of numerous path-breaking cases during her time at LDF, including VC versus Abbott, a successful federal challenge to Texas's restrictive and discriminatory voter ID law, NUL versus Trump, which sought to enjoin President Trump's 2020 executive order banning diversity, equity, and inclusion training in the workplace before it was later rescinded, and Hayden versus Pataki, a case challenging New York's felony disenfranchisement laws. Prior to rejoining LDF in 2014, Janae was Associate Dean for Faculty Scholarship and Associate Director of the Ronald H. Brown Center for Civil Rights and Economic Development at St. John's University School of Law, where she was also a full-time professor of law and served on the law school's senior leadership team. After 2 federal clerkships, Janae began practicing law as the 1998 recipient of the LDF Fried Frank Fellowship. We're very excited to hear more from Janae, beginning in just a few minutes. I'm next going to introduce Catherine Lehman. Until January 20th, 2025, Catherine E. Lehman was the Assistant Secretary for Civil Rights at the United States Department of Education, a role that she also occupied during the President Obama administration. Catherine's prior government service is extensive. It includes being Deputy Assistant to President Biden with respect to racial justice and equity, and serving as the chairperson of the United States Commission on Civil Rights from 2016 to 2021. Catherine was also a member of California Governor Gavin Newsom's cabinet, serving as Legal Affairs Secretary from January 2019 through January 2021. In addition to her government service, Catherine litigated civil rights cases at the ACLU Foundation of Southern California, National Center for Youth Law, and Public Counsel Law Center, and she clerked for the Honorable William Norris of the United States Court of Appeals for the Ninth Circuit. Thank you for joining us today, Catherine. The next panelist I'm going to introduce is Professor Kimberly Robinson. Kimberly Jenkins Robinson is the founding director of the Education Rights Institute, and she is the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law and the White Burkett Miller Professor of Law and Public Affairs at the University of Virginia School of Law. She is one of the nation's leading education law and policy experts with respect to educational equity, school funding, education and democracy, and educational federalism. Professor Robinson is a prolific scholar who has published 2 edited books and a diverse array of articles, book chapters, and editorials. Before Kimberly began her career as a professor, she practiced law in the General Counsel's Office of the United States Department of Education and as an education litigation attorney with the Hogan and Hartston law firm in Washington, D.C. Last, but certainly not least, I'm going to introduce our panelist, Jonathan Smith. Jonathan currently serves as the Chief of Staff and General Counsel at the National Center for Youth Law. From July 2021 to April 2024, he served as Deputy Assistant Attorney General in the Civil Rights Division at the United States Department of Justice. In that role, he helped oversee the division's investigatory, enforcement, and policy efforts. Jonathan previously served in the Civil Rights Division of the United States Department of Justice as Senior Counsel to the Assistant Attorney General from October 2014 through January 2017. He also served in New York State government as the governor's deputy secretary for civil rights and workforce, and as the interim commissioner for the New York State Division of Human Rights. He has previously worked as the vice president and legal director at the MacArthur Justice Center, as the legal director of Muslim Advocates, and as a staff attorney here at the NAACP Legal Defense Fund. Jonathan, similar to Janae, began his career as a litigation associate at Fried Frank, and before that, he was a law clerk to the Honorable Carl E. Stewart of the United States Court of Appeals for the Fifth Circuit. So thank you to each of our panelists for being here with us today, and we're going to get right into the conversation. So this is a moment where the Department of Education itself is being uniquely challenged. President Trump has signed an executive order calling for the abolition of the Department of Education. The Secretary of Education has already cut nearly half of the department's staff. So I think it's important to begin by talking about what the Department of Education is and what its value is. And Catherine, if you could walk through our audience, what are the basic functions of the United States Department of Education, and what would the consequences be of eliminating it?
Well, starting with the second question first, the consequences would be dire for student rights in the country, and it's a terrible idea to get rid of it. It's an idea that has come up over and over, and so far has not actually taken place. It would actually require an act of Congress lawfully to get rid of the Department of Education. But the actions that the Trump administration has taken to date have effectively ended the effective operation of the Department of Education. I think that's incredibly damaging for kids already. But to start, at its core, the U.S. Department of Education is a civil rights agency, meaning that its function is to ensure equal opportunity for students in all walks of life in all federally funded schools. And it accomplishes those ends through grant making, through guidance generation, through working on equity in delivering access to higher education through Pell Grants and through federal student aid. There's really a very, very wide set of functions that involve sharing with school communities best practices, having data about what works and what doesn't. There's an actual what works database at the US Department of Education that is available for instructors, for education leadership, for families to research and show the effects of what actually works in a classroom and what actually works to make sure that all students are educated. And then there's my favorite part of the Department of Education, which is the Office for Civil Rights, which I used to lead. And the job of the Office for Civil Rights is to enforce federal civil rights laws protecting against race, sex, disability, age discrimination in every federally funded school. And the job of the Office for Civil Rights is hard to know right now because it's not being operated that way in this administration, but it is to be a neutral arbiter of facts and to apply the law to the various fact scenarios that can come up in schools. And I can attest that there are legion ways that people find to hurt kids and to demean their education opportunity. And the US Department of Education is a federal backstop against that harm. So ending the effectiveness of any of those functions is incredibly damaging for our students and for our democracy. The schools are, of course, the places where people learn how to be effective participants in a democracy, and gutting their actual practices or weaponizing them against the people whom Congress, in a bipartisan way, over 6 decades, charged to make sure that those students actually receive equal educational opportunity is totally anathema to our actual aspirations as a country, and horrible for preparing the students for our next generation.
Well, thank you for that sobering overview of where we are in this moment, Catherine. And I want to follow up by asking a question to Janae. But before I do, one of the other things I should have noted at the beginning is for everyone in the audience, if you have any questions that you would like to present to the panelists, please do put them in the chat, and we will hopefully have some time at the end to address those questions as well. So Janae, picking up on the last part of what Catherine was talking about in terms of the role of the Department of Education in civil rights enforcement, one of the arguments that one hears sometimes is, well, can't we trust states and local governments to do what they're supposed to do with respect to anti-discrimination laws and principles, with respect to desegregation obligations? Why can't we trust that states and local governments will be applying fairly those principles?
Oh, what a great question, Sam. I'll try not to be too facetious here, but I think we have 71 years of proof that state and local jurisdictions simply will not police themselves. We know that the full promise of Brown has still not been realized, even though we've been at this project for, nearly 3/4 of a century in terms of desegregating our public schools. And, Catherine spoke about the role of the Department of Education and the Office of Civil Rights. Catherine can tell you firsthand the volume of complaints that she received from local and state jurisdictions that continue to have problems based on race and other categories concerning students across the country, and that many local and state jurisdictions were dragging their feet or not responding at all to the complaints of children and families. So we have, sadly, a very strong record of inaction and a neglect of the enforcement of our civil rights laws. I would say that asking states to police themselves when it comes to anti-discrimination law and civil rights laws more broadly, it's like asking a driver with a lead foot to self-report their speeding. These are serial violators of civil rights laws, and we just can't expect that they will do the hard work to achieve justice for students when it's so easy to circumvent civil rights obligations, especially when you do not have an active Department of Education and an active Department of Justice and an administration that cares about these issues. That's why we have accountability measures. They exist for this very reason. And it's why groups like the Legal Defense Fund are so important, and with many of our colleagues in the field, to enforce civil rights laws, to make sure that our students are protected, and to use the richness of the Brown decision. Brown was a mandate to end racial segregation in public schooling. But we know that across the country, and especially in the South, there was immediate resistance, what we call massive resistance, to evade desegregation. And that massive resistance was checked by the Supreme Court in a subsequent decision a year later, but it persisted and it never fully resolved. So we know that in Virginia, for example, segregationists closed an entire school district for 5 years and prohibited all students from learning in integrated public schools because they did not want Black and brown and white children to learn together. And if we look at the current tactics, the freedom of choice plan, school choice, or tuition vouchers, these are similar tactics to evade the integration of our public school system. So where massive resistance has failed, many white families have chosen to flee segregated neighborhoods rather than build integrated communities. They've chosen to really abandon the project of Brown. And I will say that the Supreme Court has also, frankly, been complicit in this. I mean, just about 20 years after Brown, when we were still actively trying to enforce it, in a case called San Antonio versus Rodriguez, the court permitted states to maintain inferior public school systems where the inequality was a direct result of the differences in the taxes collected in each district. So we all know that, our local taxes help to fund the school systems in our local jurisdictions. And when you have income inequality, when you have wealth disparities based on race, when you have these economic disparities, our schools suffer for it. They're not funded equitably. And so, it's been about 50 years since the Rodriguez decision, and the result is very chronically underfunded school systems throughout our country. And I know that we'll talk a lot more about the role that the Department of Education has played in trying to, right that wrong, but there's still so much work to do. And we know that it is going to be more difficult to do that with the Department of Education under direct assault.
Thank you, Janae. So we've already been talking about ways in which the administration is no longer doing what it needs to do to enforce civil rights laws and principles. Kimberly, could you talk to us a little bit about something else we're seeing, which is potentially the use of the Office of Civil Rights, the use of other Department of Education resources to not only stop enforcing civil rights, but actually to be used as a tool to oppose civil rights laws and to oppose the progress that should be at the core of the Department of Education's mission?
Yes, I'm happy to do that. So one of the things that what has happened is that President Trump issued an executive order indicating that measures that were to advance diversity, equity, and inclusion were unlawful and are a violation of our civil rights. And so to sort of order the executive branch around that, on February 14th, there was a Dear Colleague letter that was issued. That letter said that the Students for Fair Admission case, which everyone calls the Harvard case, basically tells us that diversity, equity, inclusion efforts are unlawful. That's simply not true. Most diversity, equity, inclusion measures are enacted to address discrimination and to make schools, as the name suggests, a place where everyone feels welcome, everyone's history is taught. And so we had not been doing that for quite some time. And so there was a significant push to move toward that. And so the February 14th letter said, essentially that the Harvard case says that you cannot consider, enact diversity, equity, inclusion measures. It specifically noted discrimination against white and Asian students, failing to mention the discrimination against Black, Hispanic, and Native American students. And it further just really kind of took Title VI and sought to kind of weaponize it and point at districts that were trying to be more inclusive by saying Title VI prevents you from doing that. Another thing that they did was they issued a series of frequently asked questions that sought to further explain what they meant in the first time, because it was very vague what the letter said. People were like, what does this mean exactly in practical terms? And they still haven't defined exactly what they mean by diversity, equity, inclusion. But they did seek then in April, I think it was either March or April, to have school districts and states certify that they were complying with Title VI consistent with this new interpretation. And of course, because the interpretation is not correct, then you have districts then agreeing to, enact the interpretation that's wrong. And then that you can bring a False Claims Act, case against them if they sign like, well, we agreed to get rid of diversity and inclusion. And if they're not doing it, that is not permissible. So that's certainly one of the biggest concerns. I think one of the reasons why this is so dangerous is that many people don't fully understand what Title VI prohibits. It prohibits race, color, and national origin discrimination if you receive federal funds. And what that means is that applies to every area of school district operations, as well as university operations. So that's everything from access to gifted and talented classes and AP classes. That applies to discipline. That applies to racial harassment. There's just that also addresses the needs of multilingual learners. And so because there's not a robust public understanding of Title VI, I've even talked to attorneys who say, oh, I think Title VI means the same thing that Brown said, which is that you can't segregate students on the basis of race. Title VI says much more than that. And so because of the lack of understanding, when there's confusion, you can sow, the wrong interpretation, and then people act on that out of fear. The other thing I've been trying to point out to people is notice that they fired most of the lawyers in the Office of Civil Rights. So what you have is an administration that's seeking to, in saying that everyone has to get rid of DEI, but there are no lawyers. There aren't any, I wouldn't say no, but there aren't a significant number of lawyers to enforce that interpretation. So it's important to understand that this seeks to really govern by fear rather than by sort of taking action on that. Now that could change over time. It's a dynamic situation. Something new comes out every day, but that is certainly one of the things to keep in mind.
Great, thank you. So Jonathan, we're seeing similar retrenchment with respect to the Department of Justice itself. Could you talk a little bit about how we've seen priority shift under this administration with respect to how the Department of Justice is addressing civil rights in our nation's schools?
Sure. Well, first, just thank you for being here. It's a real pleasure and honor to join my former LDF colleagues for this really important and timely discussion. Janae talked about the massive resistance that we saw in the aftermath of the Brown v. Board decision. And I think that's a really important place to start the story, because that's actually the start of the Civil Rights Division. The Civil Rights Division was created by the Civil Rights Act of 1957, which was the first Civil Rights Act since Reconstruction. And the reason why the act passed through Congress over the objection of people like Strom Thurmond was because we saw the massive resistance, and we saw that school districts simply were not desegregating. And so Congress gave the Justice Department the authority to go in through Title VI, but also through Title IV of what ultimately would be the Civil Rights Act of 1964, to actually have the authority to go in and address schools that were not desegregating, that remained segregated and entrenched in their discrimination. And so the Civil Rights Division is very much connected to the story of Brown and the failure of Southern states and cities and municipalities to respond to their obligations. The Civil Rights Division has been called the crown jewel of the Department of Justice. And that's because it has the affirmative obligation of enforcing civil rights for all people in this country. And it gives teeth to the constitutional guarantee of equal protection. And so if I could just read what is the actual mission statement of the Civil Rights Division, it is to protect the civil and constitutional rights of all people in this country, enforcing the Constitution and federal laws of the United States in pursuit of our founding ideals, fundamental fairness, equal justice, and equal opportunity for all. And so that is the purpose of the Civil Rights Division. And just like the Department of Education Office for Civil Rights, we see how that purpose has been thwarted and morphed by this new current administration, which has turned the Civil Rights Division into a sword that they're using to go after their enemies and people who they just simply disagree with. And so they have created new mission statements, which are devoid of the statutory mandates that we see in the Civil Rights Act of 1964, the Voting Rights Act of 1965, the Fair Housing Act of 1968, and instead has its own mission, which is really about advancing this cramped version of DEI, this mission of going after voter fraud, all these things that we know are not actually civil rights issues and concerns. And so we see this also in the context of school desegregation. You know, the Civil Rights Division has 131 school desegregation cases on its docket, stemming from the Brown era and from the Civil Rights Movement. And now simply they don't have the staff to even enforce those cases because they are driving out the experts, the people who have spent their careers working in the Civil Rights Division to do this work. You know, I think when people think of the Civil Rights Division, I often say they think about the kind of sexy cases that come across our newspapers. You know, the death of George Floyd, the prosecution of the person who did the Tree of Life synagogue massacre, or the Top supermarket in Buffalo. But the reality is that there are regular kind of bread and butter cases that are taking place every day that the Civil Rights Division is designed to protect. And I would put the school desegregation docket in that bucket. That these are cases that are really about making the promise of Brown real for people, for communities, for families all across the country. And we see that the department is saying, we're not interested in doing that work. We're not interested in enforcing those consent decrees. And that is a travesty, not just for the department, but for the country as a whole.
Thanks so much, Jonathan. I'm so glad you talked more about the desegregation docket. And I think for LDF, that's, for us, one of the challenges in this moment is the need to be a bit of a private Department of Justice. We have a number of desegregation cases ourselves, and I think a lot of people don't realize just how many school districts in this country have never eliminated the vestiges of segregation that existed prior to Brown. And so to just briefly mention two very recent examples, in 2018, the Court of Appeals for the 11th Circuit in an LDF case affirmed a finding of the trial court that a small district in Jefferson County, Alabama, was motivated by intentional discrimination in trying to circumvent its desegregation obligations by actually seceding from this county school district. They attempted to secede from the county school district rather than comply with their desegregation obligations. Another case from 2022 in the Fifth Circuit Court of Appeals involving St. Martin Parish, which is a parish in Louisiana, which is what Louisiana calls what most other states call counties, was found to have never addressed the vestiges of segregation with respect to where students go to school, where faculty are teaching, and racial discrimination in student discipline. So these are not issues from the 1950s, 1960s, 1970s. These are the same kinds of issues that we're continuing to see today. So I want to shift a little bit. We've talked about sort of the challenges of the moment we're in. I want to shift a little bit and talk about what some of the opportunities are for pushing back against some of these challenges and for continuing to move forward. And maybe starting again with you, Janae, we heard from Kimberly about the Dear Colleague letter and the certification that was required by the Department of Education. There's been some success, though, that advocates, including LDF, have had in pushing back against that effort by the Department of Education and the Trump administration. I was wondering if you could tell us a little bit about that and kind of more generally what you're seeing from advocates that have been successful so far in pushing back against some of what we're seeing from the administration.
Yeah, happy to do that. And one of the things that I wanted to share just for broader context is, the number of complaints that OCR gets so that you understand how important these interventions are. And Sam, you mentioned that, LDF and other organizations like ours have had to stand in the breach and be an alternative Department of Justice, a position we are familiar with from the first Trump administration. Now we have to be an alternative to almost every agency in the federal government, because not only have their employees, along with decades of expertise, been siphoned out of those agencies, as Jonathan mentioned, they've also been replaced with hostile mandates and charters that are so divorced from the original intention of these agencies. And so when I think about OCR and during fiscal year 2024 alone, the fact that the Office of Civil Rights in the Department of Education received nearly 23,000 complaints overall, which was a new record high, I think a reflection of the times we're in and the climate that we're all experiencing. Of those complaints, about 37% alleged disability discrimination, 19% contained allegations of discrimination on the basis of race, color, or national origin. This is just last year, right? So this is present day discrimination that our students across the country are experiencing. And we know that OCR has reported an increase in harassment on the basis of race and sexuality and gender identity. And LDF has worked very hard in a number of jurisdictions. One, example of one of the worst cases that we've had to represent students and families on comes from the Carroll Independent School District in Texas, where children were, regularly called despicable, racist, offensive names, where they were physically attacked. And to our earlier point, the school district, the local school district, was aware of it, and they failed to appropriately address it. And in some instances, they even condoned the harassment. So that's just a flavor of what our students are experiencing and the lack of protection that they expect now that this administration has, really declared open season on almost anyone who seeks to enforce civil rights. So what advocates like the Legal Defense Fund have been able to do is to make sure that we, at a bare minimum, we educate the public. That's part of our mandate at the Legal Defense Fund, is to make sure that we are sourcing people with the right information. Obviously, we also litigate, we do policy work, we do research, we organize, but starting with this fundamental reshaping of the narrative is critically important. So when the Department of Education issued a Dear Colleague letter on February 14th of this year, and it grossly misstated civil rights laws, and it threatened to cut funding to pre-K through 12 schools and colleges and universities that were trying to level the playing field, that were trying to right all these wrongs that we've talked about, 3 federal courts in different states have barred enforcement of this Dear Colleague letter and related actions, which would have had a very detrimental effect on Black students and other students of color. And that was a case that LDF brought along with some of our partner organizations. And we challenged the content of that Dear Colleague letter because it violated the First Amendment. It violated due process. It violated the Administrative Procedures Act. And we also made sure that we issued something for teachers and students and families to comprehend how very wrong that Dear Colleague letter was, how it misstated the law, how it misstated facts. So it was a dual-pronged approach of public education and litigation that really helped to allow local school districts to make decisions on their own about how much they were going to comply or felt cowed by this Dear Colleague letter. And then, of course, in the courts, after these wins, LDF and the ACLU and Democracy Forward jointly sent a letter to every state education agency and over 100 of the largest school districts in the country to inform them about these court orders and to let them know that this misguided document had been enjoined. So that win was really, really important to correct the record, to give school districts the leeway that they need to try to enforce civil rights laws and to protect our children and students who are in schools. And of course, we're continuing to work with students and families and arm them with this information and work with school district leaders who, I should note, not everyone is anti-student in the way that this administration seems to be. So there are many wonderful teachers and school administrators who want to do the right thing and want to work with us to protect our children and make sure that they have an equitable education experience. And so that's why we're continuing to file these lawsuits. It's why we've sued to stop harmful actions on behalf of the NAACP and the National Academy of Education and the National Council on Measurement in Education and the Mid-Atlantic Equity Consortium. We're representing a wide range of stakeholders because in addition to what we saw with the Dear Colleague letter, we know that there are efforts to stop data collection. And data collection is at the core of what we need in terms of information to bring lawsuits. It's at the core of what, any Office of Civil Rights needs. And when this administration says it no longer wants to track data based on race, it no longer wants to, really stay on top of how the climate in our public school system is evolving, we know how very dangerous and detrimental that can be to students. So we sued to make sure that we do not lose this important information that helps us enforce civil rights laws. So that is another lawsuit that we've brought that we're very proud of and we think is as important as any other, because without that core information, we are left at a disadvantage in terms of enforcing civil rights.
Thank you, Janae. So as you said, not every school official, not every school district, not every community is sort of anti-student. Catherine, could you share with us some other more positive examples, things that you're seeing where you see that school districts or states or other entities are really sort of stepping up in a positive way for civil rights in this moment?
Right. I guess I want to say a couple things. One is all of us would do well to remember that the law has not changed, that the president's executive orders, as much as they have an aspiration to divide us, do not require us to divide ourselves. And nothing that this administration has done in this area has changed the law. Congress writes the law. The president's executive orders direct president's executive agencies in how they should proceed. But the law is unchanged. It still protects all of us against discrimination based on race, color, national origin, sex, and disability. And each of us has that right still moving forward. So I love it when I see school districts and states and colleges and universities remembering that and complying with the law as Congress wrote it, and as we have had these guarantees now for 6 decades, that the requirements always have been, and this is the law as Congress wrote it: no person shall experience discrimination. So that means every day in every school, every educator, every administrator, everyone involved in education is obligated to ensure that no person experiences that discrimination. The goal has been, and the necessity has been, that we have a federal backstop against harm to ensure that that goal is the lived experience for students, but there's nothing that holds any educator back from delivering on that promise every day. And my hope, my expectation is that all of us in schools, all of us who love schools, are working to make sure that our schools deliver on that promise every day. So good news is there's lots of things that schools can do and lots of things that many educators in many parts of the country are doing. It's been beautiful to me to see those jurisdictions who have joined in lawsuits, those jurisdictions who have stood to say, this is not how we will educate our kids. This is not how we will deliver for our students, and we will continue what we have guaranteed in offering inclusive education. It's also been in my life as a civil rights litigator and as the chief civil rights enforcer in the nation's schools until the election forced me out of that gig. It was really beautiful to get to see the kinds of things that school communities were doing. Very often we saw very ugly forms of discrimination that confirmed the need still to continue the work. But even in that work that was often so painful and so difficult, we would see school communities who were doing extraordinarily beautiful finding extraordinarily beautiful ways to offer equal educational opportunity. So, in a school community where we were evaluating whether the district as a whole was offering equal education opportunity, in particular in access to high rigor courses and in delivering on ensuring that students could experience their education without discriminatory discipline, We saw some serious dereliction of duty in some of the schools in the district, but there was this one school that was a beat the odds school where the district itself was showing what it should do. It had offered after school programming, it had offered extended day programming for their students. They had changed their disciplinary practices. They were ensuring that all of their kids could have access to their high rigor courses. And over time, their kids were taking and succeeding in the courses. They were staying in school. They had positive behaviors in class. They were not distracting themselves and their peers from their educational opportunity because their educators communicated to them that they believe in them, that they're ready for them, and that their schools would be there to serve them. So, we were able, as we were working with that district on very important needed changes to move forward, we were able to point to its own school in its own district and its own programs to identify things that it could do differently and better moving forward. So that was fun and gratifying, and also a useful light for ways that the district as a whole could make changes. We've also seen, following the Students for Fair Admissions decision, many colleges and universities taking serious steps to change the landscape for the way that they admit, the way that they support, and the way that they graduate their students to ensure that they continue to offer fully equal, fully diverse educational opportunity for all of their students. And just to give you one example that I particularly love, Fresno State in California, a state public institution, worked with 29 local school districts to guarantee admission to students to Fresno State before those kids are even seniors in high school. I think it's starting in their sophomore year in high school. Those students know that they are guaranteed admission if they maintain a C or higher average in their schools in their district. They're welcomed to come to the campus in the summer to take courses, to imagine themselves as college students, to experience what it's like to be a college student. They're told that their financial aid will be so that they know that they can access college and that they can go. And so the university is communicating to a set of communities that often have first generation students, often don't have a college going culture in them. The college is for you, and that we will make sure that you can come and you can succeed here. Those are kinds of steps that any school can take. Those are kinds of ways that schools can open their doors and make sure that more and more students can be in them. So I especially hold dear now, but always, given the kinds of forms of discrimination that I see so often, I am especially gratified to see our education leaders insisting on education excellence and opportunity for all of our kids so that all of them can have opportunity in school.
Well, thank you for those inspiring examples. And I think this is a great segue actually to one of the questions that we got from the audience, which I wanted to pose to you, Kimberly. And the question is, what can community members who are not lawyers do to support public education? And so interested to hear your perspective on students, parents, researchers. What can everyone do to support public education and equal educational opportunities?
Yeah, so that's a great question. I think one of the things to understand now is that this attack on DEI is really meant to be a bit of a red herring. In other words, as we looked at coming out of what happened with George Floyd and people were focused on Black Lives Matter and other issues of civil rights, I think part of what you have to understand is there was really an awakening of the existence of systemic discrimination, race discrimination. People saw that it was alive and well. I know I live in Charlottesville currently. People here saw it walk down their streets, right? And so I think it's important for people to, the public, to hold their school boards and school districts accountable for opportunity gaps, because educational opportunity gaps persist, and they persist along race, class, geography, and other measures as well. And I think it's important for us to focus on that, because Brown wasn't just about children learning together. The lawyers who litigate Brown were very much focused on green following white. In other words, Black students would get access to high quality schools that were well funded. And if you look at the data today, Black students are twice as likely as whites to be in a school without adequate funding, and 3.5 times as likely to attend a school that's chronically below adequate funding. And that's data from the Albert Schenker Institute. And so I think we have to understand that we've never fully ended separate and unequal. We've never fully dismantled that. And the opportunity gaps that persist are a legacy of that. And so we need to address that. And that can be the work of community members, social scientists. The lawyers can help, but the lawyers are not everything. I mean, I'm a lawyer, but I know that there are limits to the law, right? And so the law doesn't cover everything. I think also it's important to elevate in your community equity-centered leadership. And that means decision makers who are going to put equity at the center of their decisions and who are not afraid to do that. Because when you focus on equity, you make sure that all students' needs are served. That is all students. That is not just Black and Brown students, and that's not just white and Asian students. It's all students. And I think that is something that is not being discussed at this current moment, but I think needs to be, which is we have to have leaders at the school level, at the district level, on school boards, who are focused on making sure that all students are served well, that equal educational opportunity is not just something that was said in Brown, but it's a reality, and who are willing to roll up their sleeves and really put in the work to get that done. And then I think also, as we all know, the key for this is that elections have consequences. And I think we have to prepare for the next election. And also, school board elections, you get 10 to 15% turnout for school board elections. People don't turn out for those elections. They matter greatly. And so it's really important to turn out for your local elections, find out, like when I meet someone who's running for school board, I have like a nice list of so what do you stand for? What are you trying to do, right? You want to understand who you're voting for, not just who had the best sign, who had the most signs around, but like who is standing up for our kids. And I think that's really important, that you can act at the local level, the state level, and the federal level to really push forward, leaders who are going to help to push equal educational opportunity. So, and actually, sorry, can I just add one more thing? One of the things that we're doing, I founded the Education Rights Institute almost 2 years ago to help school districts and states understand, and the public understand Title VI and educational opportunity gaps, and sort of how our laws and policies are failing to address this, but how this is within our grasp, that we can take action to address this. And I think that's, something that is, as we're sort of on the defensive right now, I think the push forward has been stalled. And I think we not only need to push back on the misinterpretation of Title VI, but we need to push forward on making sure that opportunity gaps are closed, that Title VI is enforced with fidelity, and that we get the law and policy reforms that we need to protect all students.
Great, thank you. So Jonathan, I want to come back to you, and there's a question from the audience that I wanted to ask, and then maybe connect it with another question. The audience question is about the impact of the executive orders that we've seen seeking to end disparate impact as a source of liability under a number of federal statutes, as well as executive order related to school discipline. I will just note that, as Catherine said, executive orders are not laws. So just sort of putting that out there as initial, but, sort of interested to get your take on those executive orders. And I think maybe in the context, if you could also sort of address how thinking about the legacy of Brown in the way that it should be thought about is an opportunity to create more equal access to our society generally in areas beyond education as well.
If I could also make a shameless plug from Kimberly's question about how we can support public education. Just on Friday, I'm really proud that my organization, the National Center for Youth Law, announced the Public Education Defense Fund, PEDF. We need a better acronym perhaps, but it is about doing the work that the Department of Education Office for Civil Rights is not doing, will not do, but we know needs to be done. And I encourage you to go to our website to get more information, youthlaw.org. But it's really important that all of us, and I'm a litigator, I'm a lawyer, but we're not going to litigate our way out of these problems and challenges. We need to come together as communities, as people of goodwill, and demand more from our government. And if our government will not do it, then we have to do the work ourselves. And I think that's the legacy of Brown too as well. Like Thurgood Marshall could have waited for the Civil Rights Division or for the Department of Justice to get its act together, but he said, no, I'm not going to let generations of young people suffer because of that. And I think it's incredibly important that we do the work that we know we have to do right now to make sure that we are standing up for public education all across this country. You know, I could speak for an hour about disparate impact. I know I don't have the time to do that, but what I will say is that we know that that disparate impact is an incredibly important tool for establishing discrimination, and particularly in a world in which disparate treatment or intentional discrimination is increasingly hard to prove. It's incredibly important that disparate impact be a tool that we can use to actually hold people who engage in discriminatory conduct accountable. And both of those executive orders are designed to take away that incredibly important tool and theory of liability. And just because it's not front page news doesn't mean we shouldn't be paying attention to that executive order and what it means for discrimination going forward. Then finally, to answer your question about outside of education, you know, I think we need to be talking about discrimination in housing and in lending. You know, when I was at DOJ, we launched the Combating Redlining Initiative, which was designed to deal with the scourge of modern day redlining, because we know far too many communities are locked out of opportunities, whether that's schools, whether that's jobs, whether that's access to places of public accommodation, because simply where they live. And so, and we know from the Milligan case that the Supreme Court has blocked the ability of courts to actually factor in that residential segregation in developing remedies to school desegregation. And so I think talking about fair housing, fair lending needs to be a part of the conversation if we want to have a more equitable and more just society.
Thank you. All right, so we have time for a lightning round with the question that may not easily lend itself to that. If you each could spend a minute talking to us about, in your ideal world, what does public education in this country look like in 25 years? And then we're gonna turn it back to Todd to close this out. So, and I'll start with Catherine.
Right. Well, my hope is that we actually live the equality that we're promised in 25 years, and I deeply regret that we haven't lived it yet. I mean, the strides that we have made in education are amazing and legion in my lifetime, in the lifetime since the Brown decision in these 71 years. And it is shocking to me that we are still litigating some of the same issues that we were litigating all those years ago. And we're still having to have the same conversation. So what I would like is for every mother's child to be able to expect going to a neighborhood school, that school will be fully resourced, fully ready to serve every one of those kids, and will meet every kid's dream. That is not too much to ask. That is actually our federal guarantee. That is actually our national aspiration, and we can get there, but we have to insist on it. And it's my goal that each of us will be working together to make that happen.
Thank you, Catherine. Kimberly.
Yeah, so I think, as you're right, this is one that would be hard to sum up in a minute, but building on what Catherine said, you know, our history has shown that without legal guarantees, you really unfortunately cannot fully advance the needle to deliver to students what they need. And so when you think about, for example, the Individuals with Disabilities in Education Act, children with special needs were being locked out of schools, right? Until you had a law. I do believe that we need an actual federal right to education. I've written about it extensively, and that, you know, we need some kind of floor that is not federalizing our education system. It is merely setting a floor that all students, as Catherine said, have a right to a high quality education. Our state rights to education are patchwork. Some students have a right to a high quality education, but far more have a right to walk in a school building that might be crumbling, that doesn't have good, you know, HVAC. We saw that with COVID. And so I do think that we need additional guarantees to ensure that all students have a right to education and a high quality education that prepares them to be college and career ready and engaged civic participants.
Thank you. Jonathan.
So a few weeks ago, I had to go to career day at my daughter's school. She's in fifth grade. And I will confess, I was very nervous, like much more nervous than even during this panel, of going before her classroom and having to talk about my job, which is being a civil rights lawyer, which is not something that I thought most 10-year-olds would care that much about. And I could not have been more wrong. They were super engaged. I had just finished their unit on the Constitution, and so they were like, "We the people," and they knew all about the Bill of Rights, like you can't like quarter soldiers, and all of these like random things that I confess I forgot about our Constitution. And I think that's what I want for all students and all families: the right to be in a diverse, integrated environment, to be engaged in our democracy, to do the hard work of citizenship. The reality is that like my daughter had that experience, but far too many students don't. And to Kimberly's point, they go to schools where they don't have those types of opportunities. And I think if we can get to a point where all students can be in that type of classroom and that type of school, I think we will have made tremendous progress as a society.
Thank you. Janae.
Yeah, well, I just want to build on everything that my colleagues have said. I agree 100%. And at LDF, it's not just a hope for us, it's actually our mission to ensure that we finally realize the true promise of Brown. Brown is a blueprint for the public education system that this nation needs. It's not only a nice to have, it's a necessity if we want to continue to thrive as a multiracial democracy. One of the things that came out of Brown that I treasure the most in terms of the insights that those 9 justices gave us in their unanimous decision is that they said that education is the foundation of good citizenship. If we want a strong democracy, if we want good citizens or good residents of this country to be part of the body politic, to continue to evolve this country, to realize, the fullness of its promise, to see our diversity as our strength, we need to have a strong public education system. And Brown has given us such a good roadmap on how to get there. So my hope is that we will continue to realize our mission to ensure that equal education is available to every single child in this country, education that is culturally responsive, education that teaches our true history, education that mines the potential of every human being and enables them to enter society fully prepared as adults to be good citizens and to be good people. I think it's as simple as that.
Thank you, Janae, and thank you to each of our panelists. And I'm going to send it back to Todd to close us out.
Had to get permission to turn my camera on. Thank you, Sam, and thank you to all our panelists, Janae, Catherine, Jonathan, Kimberly, for your amazing insights. Just a few reflections. We heard about the importance of defending the legacy of Brown and its promise, not only for the purposes for education, but certainly as it applies across sort of the civil rights infrastructure. We heard about efforts to remove the important pillars like the Department of Education and like the Department of Justice, which have stood historically on the side of equal opportunity across all of those sectors, but particularly around education, and the importance of organizations like LDF and the National Center for Youth Law and other entities to sort of step up and step into that breach to make sure that rights are protected. And also we've heard now more than ever how important it is to protect that legacy because it's under attack. And since it is at the core of so much of what we consider to be important in our democracy, we can't let that legacy go. And finally, we learned about the importance of working across all the sectors, all of the silos, make sure that we were being as robust. As one of our colleagues said on the panel, we can't litigate our way out of this, and we need really to have a thorough, complete partnership across all of the community members folks in academia, researchers, litigators, advocates to make sure that we are advancing equal opportunity in education. So I want to thank Sam and our panel once again. I want to thank our colleagues, Ray Lee and Sarah Saul, who partnered in organizing this panel. If you want more information, you can visit our website, NAACP Legal Defense, LDF, NAACPLDF.org. Follow us on social media, including Substack, and stay tuned for more events like this. Thank you all for joining us and have a wonderful day.
Thank you.